Welcome to another Talking Feds one-on-one. Among evolved democracies, the United States is in many ways surprisingly lackluster or middle of the pack. We're in the mid-20s among countries for reported happiness, pretty low for infant mortality, relatively low for life expectancy, high and fairly low in math and science scores. But there's one index in which the country far surpasses every developed country, and that is rates of incarceration. With less than 5% of the world's population, the United States has almost a quarter of the world's prisoners. I just got to say that again. With less than 5% of the world's population, the United States has almost a quarter of the world's prisoners. That's 5 to 10 times higher than that of other industrialized Western democracies. What in the world is going on, and what can possibly be done about it? There's a standard political analysis that legislators have every incentive to pass longer and longer sentences to appear tough on crime, whereas criminal defendants and criminals have no political power to make their case. On the other hand, the same electoral pressures exist in other democracies where rates of incarceration don't approach ours. Now, one of the country's leading criminal law professors has written a new book shining a light on a different explanation of the phenomenon. Rachel Barkow is a professor of law at NYU, where she's the faculty director of the university's Zimroth Center. From 2013 to 2019, she served as a member of the United States Sentencing Commission, which issues the federal sentencing guidelines. In addition to her new book, Justice Abandoned, Rachel's the author of Prisoners of Politics, Breaking the Cycle of Mass Incarceration. We are also longtime friends. Welcome, Rachel, to Talking Feds.
Oh, thanks so much for having me.
All right. Congratulations on the book, Justice Abandoned, How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. By Harvard University Press, published a couple months ago. So you begin with this fairly stunning contrast that may take many readers by surprise, with the incredible sort of disproportion between our population and almost a quarter of the world's prisoners, nearly 2 million people. And criminologists have analyzed this from many angles, but your book traces the effects of U.S. Supreme Court jurisprudence in 6 different areas. We'll get to those in a moment. Let's go a little further back to the founding in the Constitution, which you do talk about, which sets a kind of baseline of limitation or sort of moral justification for punishment that, in your view, the Supreme Court has eviscerated. So take us back. What's your sense of the provisions, but also just the general thrust of the Constitution with respect to criminal punishment?
Yeah. So, I think some people associate looking at the founding and the framers and originalism with very conservative outcomes and ideas. And this is an interesting area where looking to founding principles would, I think, produce more liberal results and outcomes, because the framers were really attuned to government excess and abuse when it comes to criminal law and enforcement. They were really worried about it. They had experience in England with what were known as the bloody codes, where you got capital punishment for almost everything. The king exercised discretion arbitrarily and abusively against political enemies. And they were adamant that they were going to create a constitution that checked that kind of overreach and abuse. So when you read the Constitution, from front to back, one thing that you notice is that, there's a lot of emphasis on criminal matters, or even you just look at the Bill of Rights. The Bill of Rights really focuses on criminal proceedings and making sure that defendants have lots of protections in those. And that is a reflection of the framers' concern that they wanted to make it very difficult for the state to be able to imprison and take liberty away from people using criminal process and punishment.
And it makes sense just thinking of the position of the framers and where they had come from, just the loneliness and paradigm of justice of the single person facing the what they viewed as the massive power of the state. Okay, so you focus, as we've mentioned, on Supreme Court decisions in 6 different areas. let's stick with the general sweep for another few minutes. So some people might see it as ironic or surprising that the cases you note, these 6 cases, begin in the 1960s, which people have generally seen in culture as the high watermark of permissiveness toward criminal defendants. But you've a sense that, well, let me just ask you, where was the court in the 60s that might help explain, if there's a good explanation, its strong doctrinal turn then toward more and longer punishments?
Yeah, so it is actually kind of interesting because I think when people think of the 1960s and the Supreme Court, they have a tendency to think of cases like Mapp versus Ohio, which, establishes an exclusionary rule that says you can't use evidence that was obtained unconstitutionally in a case against a defendant. Or they might think of Miranda and, the now infamous warnings that you give defendants, which again comes from a Supreme Court case. And I think the thought is the Warren Court was very liberty protecting. And I think what people miss is that, in fact, those very cases, Mapp and Miranda, produced a really severe backlash that, kicks off in the 1968 presidential election. There is a lot of criticism and animosity toward the Supreme Court. So if you went around the country, you would see signs on people's lawns that would say "Impeach Earl Warren," the Chief Justice. Richard Nixon and George Wallace were both running campaigns where they were really emphasizing the Supreme Court as part of the problem for what was violence and disorder and chaos that people were seeing around the country. So, 1968 was a time of great tumult. There's all kinds of protests. There's urban riots. Cities are burning. There's 2 major assassinations in 1968. The country really does seem like it's spiraling. And a lot of the blame for that is falling on the Supreme Court because that's what these presidential candidates are saying. And I think that is a turning point for the court in a couple ways. So one is, during the 1968 election, one of the cases I talk about in the book is Terry versus Ohio. That's being decided and deliberated during this period. And it's really obvious that the justices were attuned to the fact that if they were to decide yet another policing case against the police, the backlash would be enormous.
What makes it obvious? These are papers of dead justices or what?
I think so. Yeah. I think when you read, between the lines to things that Justice Brennan is saying in his papers, the way that they kind of vote they vote results first, reasoning second, which to me suggests that they just knew they had to reach that outcome and then they work backward. That is very obvious from the discussion. But then the other thing about 1968 that is interesting is, so in addition to that particular case, you do get Richard Nixon elected. And he is now going to appoint several justices to the court. And that is going to be the beginning of conservative dominance on the Supreme Court all the way up until the present day. So, we're going to have a majority of conservative justices who are very law and order, pro-government types of justices, people with backgrounds in government service who tend to be very sympathetic to government claims. And that is the beginning of that we then see a through line. And the last thing I'll say about that time period is, crime is rising at the end of the 1960s in America, and crime is rising at the beginning of the 1970s. And so you are seeing the politics in America say, we got to do something about this rising crime. And the Supreme Court is part of that world. It's not like they aren't also reading the papers, that they're not also concerned about that. And so as politicians are responding to rising crime, I think the Supreme Court has a sense that they don't want to tie the hands of the government in that fight. And so I do think that's a critical time period. And, and for the most part, I should say, I do think the causes of mass incarceration really are the politics that come out of this rising crime and the response to it. But what's so interesting to me is that, instead of being a break or a check on those politics, the Supreme Court becomes a willing partner, when instead what they should have been doing was kind of reminding everyone there's constitutional bounds you can't cross, which I do think would have made it much harder for us to achieve that statistic that you state at the outset, which really does make us the leader in the world when it comes to taking people's liberty away.
Yeah, it's really interesting. You see this dynamic in the political realm, and I think it maybe works in the court as well. easy for a certain stripe of justice to be very strong for procedural rights and to stand up for liberty and to be motivated by the horror of a innocent person being convicted. And it's almost conversely easy, therefore, to come down hard on actual guilty defendants, even though the treatment of guilty defendants is certainly part of what the founders have in mind. So you think of people who have gone into the pantheon of liberal justices that really were, in their sense, in their own way, sort of conservative political figures where they came from. William Brennan is a New Jersey politician. Earl Warren, the governor of California. Byron White, of course, the deputy attorney general. So, I mean, you can see, even for those who are solicitous of procedural rights, this is where they might change the balance. Okay, so Rachel, you've got 6 different areas and cases where you think the court took dramatic wrong turns. Let me just give you one more chance to. So you've given a sense of what's going on in the politics and the royal politics of the 60s and the Southern strategy. Before we get in, we'll only have time, but I want to dig deep on a couple that strike me as very significant. Anything else you want to say about the courts? In a sense, you take a step back, you're making a fairly radical charge, right? You're saying the Supreme Court follows the election returns, and you're saying that they're really contributing almost in unexpected ways to actual incarceration rates. Anything else you want to say about where they're coming from and their motivation before we jump into 2 specific areas I was hoping to explore with you?
Yeah, I guess what I'll say about that is that, so I tried in picking out, so there's a lot of Supreme Court cases I don't like. and if I were going to really write a book with all of them, it'd be a multi-volume set. It would be very large.
Right.
But
By the way, everyone, we're talking about a Silberman Scalia clerk. So her conservative bona fides are very strong. Anyway,
yeah, so ahead. I appreciate that, actually, because the cases that I pick out here, I do so because these are cases that if you were a textualist, an originalist, someone who adheres to longstanding precedent, that's what's so interesting about these cases, is they fail those really core methods of constitutional interpretation. So I do spend a lot of time on original meaning and understanding in each of these cases, because it turns out the court departs from it. And I should say, it was a different kind of court for most of this period, because although justices have always looked to original meaning, the kind of really devout originalist type like Justice Scalia, kind of emerges later in this period. And so I think one of the things you see when you look at these cases is these justices tend to be kind of freewheeling methodologists. Sometimes they look at history, but oftentimes they don't even bother. Like, they just don't care. Sometimes they read the text closely, and other times, they barely even quote the relevant constitutional provision. And so, so I am looking at it with the benefit of hindsight and the kinds of methodologies that I think are universally accepted today, and saying, even if one maybe could forgive them for deciding the case the way they did when they did it, this current court, which is very committed to originalism and making sure that, its precedent follows the methodologies it believes in, including textualism and originalism, these cases fail. And so I think it's kind of interesting in a Dobbs world, right? In a world where this Supreme Court said, hey, look, Roe might have been 50 years old, but we're willing to gut it because we're going to follow methodology where it leads us, even if it means overruling a longstanding precedent. These are those kinds of cases. These are very similar cases in the sense that, look, if you're really committed to originalism and you really care about text, you really can't let these cases stand, or at a minimum, you have to start limiting them. So I think they're interesting in that respect. I think for me, what I think is important to emphasize is not just that these cases produced, these really tragic, pernicious outcomes, which is obviously why I'm focused on them, but that if you looked at them objectively with those methodologies, they shouldn't have come out that way. They were wrongly decided. And I think there's an opportunity to get this court to reconsider it. I think, the current court is reconsidering a lot of what we have thought of as bedrock understandings. They're going to consider, for example, independent agency design, where people can only be removed for cause. The Trump administration has fired a whole bunch of people who had statutory job protection. And this administration is saying, we think that's unconstitutional. For 90 years, we've had precedent that says that setup is fine. And the current court has sent really strong signals. They're going to overrule it. They're going to overrule a 90-year-old precedent that is really at the core of a huge part of our government. So if this court is willing to do that, I think these cases are way easier lifts, much easier lifts to say wrongly decided and wouldn't create even close to the same upheaval. So that's why I focus on the ones that I do, is that I think it's interesting to look at them from a variety of constitutional methodologies and see that they fail under all of them.
Got it. And, Scalia, and to a lesser extent, Silberman, but certainly some members of the current court, Gorsuch comes to mind, have shown themselves unabashed about following an idea through to the end. And Scalia in particular, the flag burning case and others, he comes out for criminal defense, very strong on the Sixth Amendment and Confrontation Clause, et cetera. It's a constitution we're expounding. I wasn't in those chambers as you were, but I expect you heard something like that many times. All right. So, there are 6, and to my mind, Rachel, they're largely, I see the same forces maybe that affect each of them, but really these are kind of separate silos that have had different practical impact on the ground and practical contribution to the overall problem you're analyzing. And I just wanted to, as a former prosecutor, as I just want to be able to zero in on a couple that strike me as really important for starters. And then you may think of as especially incoherent in the way you sketched out. So let's start with U.S. versus Salerno, which green-lighted what's become a very widespread system of pretrial detention. That is to say, the practice of having defendants who have been charged but not convicted be incarcerated while waiting for their trial. We've just been watching this carefully in the Khalil case, the alien case from Colombia, and courts considering, do we put him in pending trial? And the United States almost always asks for it, et cetera. So, I'm interested in general. I think this will come in as we discuss it, why these 6, as you mentioned, you had other candidates. But let's just talk more in depth about Salerno and pretrial detention. Give us maybe 30 seconds on just what it is and how it works and what is kind of counterintuitive to most people's, and when they first think about it, minds about how the Constitution works.
Okay, sure. So for 200 years, every kind of legal scholar, judge, everybody just assumed you could not detain somebody after you arrested them just because you thought they were dangerous. Nobody thought that was okay. You could detain somebody because you thought they were a flight risk, because you thought that they would hurt a witness or tamper with evidence, but that was it. Because the idea was you had the trial to decide if they actually did it, and then if they were convicted, then they get detained as punishment. And so if you thought someone was dangerous...
and it's straightforward, but detain means put in the pokey.
Yeah,
they actually
you're
incarcerated.
Jail. So most of the time it's a jail, not a prison. But in many cases,
give us 10 seconds on that. We have a pretty sophisticated audience, but that's a little bit fine.
Yeah, no, my son is known
jail versus prison.
He was like 4 years old, not to distinguish this distinction. So when people are in jail, they are most people in jail are awaiting trial. They haven't been convicted of anything. It's about 2/3 of the jail population are there pre-trial, and then the rest of them are serving sentences for misdemeanors, pretty much. So sentences of less than a year, usually in most places, like, kind of smaller types of crimes.
Yeah.
Whereas prisons are run, and jails are run by usually counties, local sheriffs, whereas prisons are run by the state, and that's where people serve their sentences after conviction. They're all there after conviction. And, most of them are there for felonies. So, that's the basic distinction. And in America, our jail population of the, kind of 2 million people that you mentioned who are incarcerated, about 500,000 of them are in jails. And so that means of the 500,000, about 2/3 of those are pre-trial. So they have not been convicted of anything. And, that's the interesting thing about this framework.
Wow.
That
I don't think people appreciate those numbers. Wow.
Yeah.
Okay.
So we're talking about
full
over
quarter
400,000
of people who have not
people.
been convicted. Yeah.
Exactly, right? They have, and so if you believe in a presumption of innocence, I think right off the bat you have to ask yourself, can you really just take someone if all you've done is arrest them? The government hasn't proven its case yet. How can you put them behind bars? And often for a very long time, I should add. So in the federal system, if you're arrested for a federal crime, the average amount of time that you are detained pre-trial is over 8 months. So, you are sitting behind bars for over 8 months. You could then get acquitted, and then you're released, but you've already served, 2/3 of a year. And in some districts, by the way, the average is over a year. So we're talking about very long
And you could be divorced. You could have lost your job forever. Your life has been upended for sure.
Yeah,
okay,
and that's
go
a
ahead.
really important point, because this was the other thing I like to try to emphasize about pretrial detention. I think on everybody's initial thought about it is, it must make us safer because we're taking people that we think present dangers and taking them off the streets. And I think what people miss in that is that pretrial detention itself actually creates a risk of offending precisely because of what you just said, which is, even if someone is only detained for a few days, they're probably going to lose their job because most employers aren't super sympathetic to the idea that, you got to go serve a few days in jail. So, you
Presumption
lose your
of
job.
innocence, maybe not.
Maybe not so much, right? They get evicted because they can't make their rent. They lost their job. They lose custody of their children, who are taken away because there's no one to watch them. It is one of those life-altering things that happens. And, most people arrested are already living at the margins. So that kind of disruptive event sends people into a spiral. And in fact, empirical studies show that the pretrial detention itself makes it more likely people are going to commit crime. We would be better off not disrupting their lives, letting them keep their jobs, their stable home environment. Because when you take them out of all that, now people get very desperate. And, they're kind of struggling to figure out how they're going to continue to survive once they are released from pretrial detention. So we have lots of empirical studies that show it actually causes crime as opposed to prevents it. But, tell that to the New York Post or your local tabloid, because what they're going to emphasize.
Well, tell it to the Supreme Court. Let's get a little lawyerly. The Talking Feds audience can handle that. Salerno was a man who was challenging the Constitution. I mean, this comes from Congress, the so-called Bail Reform Act. And a few years after it's passed, he comes to the Supreme Court saying this is unconstitutional. What did he say? What did the court say? Was there a dissent? Let's just talk about how the court, because, you take a step back and there does seem to be something funky, to use the legal term, about people being incarcerated without having been convicted. But it was served up in a serious, sober, lawyerly, courtly way. Take us through that a bit.
Okay, so just one step back, which is that year of 1968 that I mentioned, Nixon gets elected and he decides, because he's run on this tough on crime campaign, and he decides he's got to do something about crime, which is actually kind of hard for a president, by the way, because it's not like the president is in control of local crime. So what Nixon comes up with is this idea that he's going to use the District of Columbia as kind of a place to show how you can deal with violent crime. And he has a member of his administration, William Rehnquist, who was going to become the Chief Justice, but at the time is, in the Nixon administration. Rehnquist helps draft a DC law that is the first law that allows you to detain people pre-trial on the basis of dangerousness. And so, that's the first time we sort of see this model. So, for the rest of the country's history, like I said, no one thought you could do this. And Nixon's trying to change the narrative. He's trying to get people to say, no, you can do it. It's okay. So one is to write this law. The other thing is his attorney general, John Mitchell, writes a law review article arguing that it's okay to do this.
Somebody on his staff writes a law review
right,
article.
But he puts his name to it.
Right.
Okay, he puts his name to it, which is interesting, right? If you think about, attorney generals.
Yeah.
And so that's like the beginning of the narrative shift that they're trying to engage in. And that eventually is going to lead to this 1984 federal law, which really is loosely modeled on that DC law. And the government, so it's going to go before the Supreme Court, and the government obviously wants to win. And so the case they bring is Salerno. So Salerno is like not just a guy. He is Fat Tony Salerno, who is the boss of the Genovese crime family, right? If you're the government and you want to say, hey, sometimes you got to put dangerous people people behind bars before they're convicted. You couldn't get a better case than the head of one of the 5 major families.
Poster child, right?
Yeah, he's perfect, and it's him and his lieutenant, Fish Cafaro. So those are the two. And in fact, the government is so eager to have them be the test case that what they don't tell the court is after the court grants cert in the case, Fat Tony was actually tried, convicted, and sentenced for other crimes. So he should have already been serving 100-year sentence, which means he shouldn't have been in pretrial detention anymore. And the government tried to engineer it to have the judge in his case say, well, I'm going to postpone his sentence so that he looked like he was still on pretrial detention, but he really wasn't.
I didn't know. That's amazing.
Yeah, it's really inappropriate. Yeah. And then even worse, I think, is that Cafaro, he was also not in pretrial detention anymore because after the petition for cert was filed, but before cert was granted, the government signed Fish up as a cooperator. So he's out and about getting evidence on other people. So he's clearly not a danger who needs to be detained pretrial because he's out. And again, the government doesn't reveal this to the court. So it's a little... it's not the government's best moment, I think, in terms of ethical lawyering behavior. But that's the case that comes before the Supreme Court because the government knows this is a great case to try to make the claim that you sometimes need to do this. And the government, in its brief to the court, says, hey, look, this isn't punishment. This is just something that the government does sometime. It's really regulatory. It's a regulatory preventive detention measure that we've used in other contexts like wars and insurrections. And cites the key case the government cites in its briefs to say this is okay is Korematsu, which some of your listeners may know is, an infamous Supreme Court case where the Supreme Court upheld the internment of Americans of Japanese descent during World War II.
Since overruled, yeah.
Yes, since, disclaimed, the Supreme Court has since said it's been overruled by the court of history. This is a horrible thing we did. But in 1987, when Salerno was decided, it had not yet been overruled by the court of history because the government is citing it in its briefs. And that is actually the cornerstone for Salerno itself, is this idea that, hey, sometimes you detain people because they are a danger. And that's what the government relies on. And the Supreme Court ultimately says, yeah, this is just a preventive detention regime that's regulatory and not punishment, super dismissive of the presumption of innocence. Oh, I should say, by the way, I can't believe I forgot to say this at the outset. The opinion is written by William Rehnquist, who, remember, is the architect of this entire thing,
right,
because he was the person who drafted that DC law. So, of course, he doesn't see a problem with it. He created it. And in his opinion, he says, look, the presumption of innocence, that's just like a burden of proof thing. It doesn't mean you can't detain people pre-trial. And even though, the Eighth Amendment talks about bail, he dismisses that too and says that's not relevant here either. It's a kind of a classic Rehnquist opinion for those of you who have read a lot of them, where he's very conclusory in his statements and there's not a lot to back it up.
And that's just a fact. That is the way he sort of puts it. And I want to say I reread the case in preparation for our discussion. And something that really comes through is the emphasis by the government and by Rehnquist of how rare this is. The proposition that they are establishing is basically sometimes you got to do this. And look, we do it in other settings. And so in that sense, I guess there's a dual responsibility to the extent, Rachel, you're kind of realigning how this all happened, because they greenlight it sometimes. Do we know how's it happen that other courts just go galloping away with it? So it really is. And I was a prosecutor. I took advantage of this as much as I could, but it's almost the burden, which is supposed to be on the government to make certain showings, feels functionally like it's the opposite. This is actually now coming up with Abrego Garcia, but very few courts seem to take too seriously the notion that government's really got to make a special showing, and it has become, as you said at the outset, a regime where 500,000 people who haven't been convicted are in the clink, as it were. So that's my main question, but also just elaborate, because it's not simply under the statute provides different ways you can get. It's not only a showing of dangerousness. So explain how it sort of works and what the government has to show, but also how did it become so friggin' huge numbers wise?
Yeah, so I would just say one cautionary tale that in researching these cases and others over my career, I have to say, whenever the government says something is going to be narrowly limited to the most violent and the most dangerous, it never is. And
Yeah.
I think about that a lot when the Trump administration talks about its immigration policies now. You have to understand it's never limited that way. So as you said, the government here claimed it was going to be very limited. John Mitchell in that law review article said it was going to be like maybe 10% of people charged would be detained. The reality is it's 60% nationwide of all people arrested are detained in the federal
And
system.
in your view, Professor, who's that on? Who made that mistake that took it from a supposedly limited regime to an expansive one?
A lot of blame to go around there. So, one would be, so at the federal level, by the way, it's 75% of all defendants. It's really,
Wow.
it's really, and so at the federal level, when we're talking about the Federal Bail Act, blame goes around. So the first, entity to blame is Congress, because they really didn't know what they were doing when they drafted this bail law. They thought that it was going to be a limited amount of time because they thought that the Speedy Trial Act would be a limiting force. Anybody who practices criminal law knows that won't be the case. But they somehow thought it would. The DC law, I should say, had a cap of 60 days. The one that was originally written in 68, you couldn't be detained for more than 60 days. But the federal law has no cap because they just thought that'll operate from the Speedy Trial Act. And so it didn't. So that's how you get those long periods of detention. And then the other thing that Congress did, so it's 1984 when they passed this law. So it's the height of the drug war. And Congress holds the view that anybody charged with a drug crime that has a statutory maximum of 10 years or more, which is almost every federal drug crime has that anyone charged with that is presumptively dangerous. And so there's a presumption that you'll get detained if that's what you're charged with. So when you look at who's detained at the federal level, overwhelming, we're looking at drug cases and so the government doesn't have to prove anything. Government just has to say, hey, look, they're charged with this drug crime, presumed dangerous. And what I think ends up happening, so part of the fault is Congress. Then I think some of the blame now falls on prosecutors and judges, because I think from a prosecutor's perspective, at both the state and the federal level, I think I get it, by the way. I'm actually sympathetic to the dynamic, because I think from the prosecutor's perspective, they're like, look, I don't want to be blamed if I don't ask for detention of somebody. And then that person goes out and they commit some awful crime. It's going to be my face on the cover of the New York Post. People are going to say, why didn't you ask to have that person detained? And so I think they err on the side of asking for detention. I also think some prosecutors recognize that if someone is detained, pretrial, they're more likely to plead guilty, and you can get them to plead to time served in some cases. And so, there's leverage that you have over them. So there's incentives for prosecutors to do it. So they tend to reflexively ask for it. And then judges, where I'm also going to cast a lot of blame, just defer to prosecutors. So, again, there's some differences between the state and the federal system. So at the state level, judges are elected. And they really worry about reelection, that there's going to be some case that can be highlighted where they let somebody go. Again, we have empirical studies. Judges give you longer sentences the closer you get to their reelection period. There's a real dynamic to elections affecting their judgment, and that includes pretrial. So, I think when they look and a prosecutor's asking for it, again, I think their inclination is just, I'm just going to give it. Because again, the risk to me as a judge, if I don't do it and then that person commits a heinous crime is, that's probably the end of my political career.
Whereas that's right. And if I can interject a little, so that strikes me as totally right. So everyone is thinking the real responsibility is with someone else. But I think the political framework matters here. So this case is 1987, 1988, if I'm not mistaken. Willie Horton, which even sophisticated talking feds listeners may not remember, but it's the classic. This is what Lee Atwater, who is the first President Bush's kind of, I don't know, Steve Cannon, how would we compare him? But he apologized on his deathbed because just something like this happened. Horton was released under Massachusetts program. And of course, Dukakis is the governor of Massachusetts, and he became a poster child for dangerousness throughout the country. And it is what everybody, flinches over, and does make it easier to just do it rather than not. And of course, and this you talk about this glancingly. Well, I want to say first, as the dissent says, and you've pretty well, I think, explained here, Rachel, no one experienced in pretrial conceives of it as anything other than punishment. You're in some ways, the jail prison distinction actually matters here, because there are ways in which jails are even sort of worse and nastier. And there is, I've done a fair bit of work within jails and prisons, and they tend to be really harsher places. People are younger, getting out sooner, et cetera. So that is part of it. But that's the basic, I think, argument of dissent. Come on, a really commonsensical argument. Good place to start your book. This certainly feels like punishment. And I'll just do one other. I think society as a whole, conservative and liberal, have become more sensitive to, especially with the drug laws, the disproportionate incarceration of racial minorities. And you cite this number, others have, that it's, I think, reduced a little, but in the early 2000s, something like a third of all Black males between 20 and 29 were either in the criminal justice system or in jail, and something like 15% were behind bars. And as you've explained it now in a way I didn't fully understand, Salerno's got a lot to do with that.
Yeah. And, I think what it does is, there's one more group to blame, which I'll say is just the public, the rest of us, because I think what ends up happening is we just all get used to the idea that this is normal. So whereas when they first kind of came up with this idea at the end of the 1960s, people did not think this was okay. And, I don't want to say that there weren't judges who were kind of setting bail really high because they actually thought someone was dangerous, because I think they were, I think they were, but they didn't think they could. They were kind of doing it on the down low. And what happens after it becomes accepted that you're allowed to do it is it really becomes prevalent. And then before you know it, everyone just thinks of this as the new normal, that this is okay. And in fact, that's what people expect. And it becomes the default. And I think now, when I talk to people and I say, it used to be that you couldn't detain people, they look at me like I'm the alien. Like, how could that possibly be? You have to lock people up right away. And I think it's just an interesting cultural narrative to see how you really can change people's understandings. And I really do think about it a lot these days with immigration, because I think this is exactly what the Trump administration is doing. It's the same playbook. It's the same idea.
Change the default. Yeah.
Yeah. And before you know it, people aren't going to question anymore whether you can send someone to an El Salvador prison that's like a torture chamber that violates human rights, because people will start seeing it as normal, and they shrug it off as it becomes normalized. And I think that is what happened with pretrial detention. But, my hope is that this will cause people to step back and say, how can that be consistent with the presumption of innocence? How can a country that really adheres to constitutional values of liberty allow that to happen? And the hope is that the court will take a closer look and realize that, even if it's not prepared to overrule Salerno completely, maybe it'll set caps on how long you can be detained or what the government needs to show before you get detained. There's ways you could find compromise spaces that look different from what we have now, which is basically just, it's so easy to get people detained pretrial that it's, I think it's a really shameful part of American criminal justice. And so, it's one of the reasons I lead with it in the book, is I think this case really is emblematic of, the kind of themes I'm exploring in the other ones, which is just the court just did this in a kind of unthinking way. You don't see the close textual analysis of the Eighth Amendment. You don't see the historical look at the presumption of innocence. None of it. It was basically just, oh, this looks like a helpful tool for the government. Let's go ahead and give it to them. And I think, that not only the tragedy of that is, as it turns out, it was all done to try to prevent crime. And, as we talked about a little bit ago, it actually makes that worse. So, it's the worst of all worlds. And the hope is that maybe we'll start to see a little bit of a rethinking of that whole paradigm.
Yeah. And it is a cross-cutting theme for understandable reasons. The rationale. Look, I'm a former prosecutor. You're a former. We are not soft on crime, although the social science really indicates that it's certitude rather than length of sentence that matters most. But we are, talking about a situation where it's just trying to bring rationality to the, as a prosecutor, you can't object to that. But I do want to state my bona fides, and I think yours, that it's not like, oh, defendant, good, let out, society needs to be protected, etc. But of course, it is a constitution we are expounding. And speaking of which, here's another that is hugely prevalent. And I think people don't, they kind of maybe know, but they don't understand. This is, you talk about your 4-year-old son knowing jail versus prison. I get this question all the time. When can the police stop you? Because we know the Constitution, we learned it in 3rd grade. You have to have probable cause, etc. And so if I'm in a car, when can I? Well, it turns out to be partial at best, the explanation that you learn in 3rd grade. And we're now on the Terry versus Ohio case, which I also chose, A, because it's interestingly counterintuitive, or people may not have thought about how does this accord with the Constitution as we know it, and B, it's really widespread. So, we could take any of the 6, but let's go to a doctrine that's sort of, I think, mind-bending when you think about it as an originalist matter, but also hugely in play. So, Terry versus Ohio, Professor, discuss.
Okay. Yeah. So Terry versus Ohio, which I referenced quickly before, was the case that was pending during the 1968 presidential election. And it's really interesting. I read a whole bunch of newspaper articles around that time to kind of get a sense of how the case was being perceived. And it was really closely watched. It was one of those cases that the country was looking at, editorials in the newspapers were writing about it. This was
officers were saying we need this.
Yes.
As they said about Miranda, which they've stopped saying, by the way. But anyway.
Yeah. So we need this. And so, as you said, so if you went and you picked up your Constitution, you would see in the 4th Amendment that, yes, a police can stop you, they can seize you, and they can search you if they have probable cause that you're committing or about to commit a crime, right? That's the standard. It's probable cause. So at the time that Terry is decided, that is what everybody understands you need. And it's pretty clear why everyone understands that, because it's the textualist argument. It is the original meaning and understanding of that is all very, very clear. So when the case gets to the Supreme Court, though, you have police officers saying, well, if all we want to do is just stop somebody and, kind of question them, we shouldn't have to have probable cause for that, find out what's going on. And of course, if we're going to stop them, we have to be safe. So we need to frisk them right away to make sure they don't have weapons. And so, it's a very pragmatic argument that basically says good policing requires us to do that. And the case that comes before the court is this case out of Ohio where this police officer, Officer McFadden, he's walking around Cleveland and he sees 2 men that he thinks looks suspicious. They are walking up and back on the sidewalk 3 times, and they're looking in the window of a store. He says it's a travel agency. Later he says maybe it could have been a jewelry store, but it's a travel agency. So there's 2 guys. They walk up and back the sidewalk. They look at a travel agency. At one point, they're joined by a 3rd guy, and the 2 men he sees initially, those 2 men are black. And then when they're joined by the 3rd person, that 3rd person is white. And that is really what makes Officer McFadden say, whoa, because I think, in Cleveland in the late 1960s, the idea that you would have people of different races talking to each other on the sidewalk like that, he thinks something is up. So that's the point that he stopped the white guy, that he stops them. And
I want to stop you right here and say something, which is, look, the officers, they, often tell me, they probably told you as when I was a prosecutor, it's sometimes hard to put into words, but we're not, just looking to arrest anyone. You get a real sense that something's afoot. And you know what? It might be afoot, and we're not saying that a spider sense of a officer is irrelevant, but says, said Mr. Terry and Professor Barkow, that doesn't mean it's constitutionally adequate to do something that's pretty damn serious. The state comes in and arrests you, and all these things kind of start. So I think there's a reason that honest cops, although I'll say one other thing that you point out in the discussion of Terry that really matters. Even pretextual probable cause stops works. If you get the real sense as a court, come on, that's not what's really going on here. Here's what's really, it doesn't matter. You evaluate the test you're about to explain to us in objective terms, which can give rise to post hoc rationalizations to officers. But I just want to make this point that the case against Terry doesn't depend on thinking cops lie all the time or disparaging them, but it does depend on a very, very clear constitutional principle, one of the Bill of Rights, as you say, that said, we need more than that. Maybe your antenna means something, but we need more. Sorry for the interruption. Go ahead.
Yeah, no, that's helpful. And I should say, so I was neither a prosecutor nor a defense lawyer, but I'm a close.
I'm sorry, sentencing. Yeah,
which is fine. So I just want to make sure so I don't have quite the same bona fides. But I'm an objective reader of the Constitution, and I get it, and I certainly understand law enforcement has needs.
And a member of the Sentencing Commission, an actual member.
And this is a really clear. Sometimes the Constitution's language, you're like, what? It's amorphous. We can't know what it means. But, this is a really clear standard that we understand it. We know what it means. And the court knew what it meant too. So when they first vote in this case, when I told you they kind of decided where they wanted to come out and then had to reason later, so they're looking around. And literally DC is on fire. Like you could look at, because one of my colleagues was a clerk at the Supreme Court during the Terry term. And, he read the chapter and he said to me, he's like, I hear what you're saying, Rachel, but what you don't understand is just the chaos of the time. Like you could look out the Supreme Court building and see DC on fire. Right. And so
William Stuntz called Terry a political necessity for that reason.
And I think that, so I get it. I got to say, it's the Constitution they're burning, but whatever, they're looking and they're seeing the chaos. And so the court, they take their initial vote at conference and they vote to allow the office say this is fine. And when they first go to write the opinion, this is the interesting thing about it. They try to write the opinion to say he had probable cause to stop them. So they don't even think they're changing the standard. Because no one thought there was a different standard. So you
always argue probable cause.
They're like, okay, we'll say they had probable cause. And what's so interesting is, that when when Warren goes to write it, and sends around when the draft goes around, the justices are like, oh my gosh, this is horrible. Because of course there's not probable cause. Remember what they did? These are just two people walking up and down on a sidewalk looking at an airline ticket office. Like that is not probable cause. So that's when you start to get the idea that Justice Brennan comes up with, which is, and you can kind of in the papers, that's where you see him start to kind of figure out, well, we have to do something, but we don't want to go too far. And I should tell you, by the way, the other thing that's interesting about going through all the papers in the case is that I think today with our 2025 lens, we certainly understand the racial justice implications of widespread policing, but they understood it in 1968 also. So they are getting briefs by the NAACP and other racial justice groups saying, do not give the police this ability because there's already bad relationships between the police and these communities of color because they're harassing people all the time. In fact, that's why you're seeing the riots that you're seeing, because you have communities that have been over-policed and abused, and they're upset and they are protesting. And, this will just be a powder keg that'll make it all worse. So the Supreme Court knew all of that. There's ample evidence in the record of all that. And so I think what, Justice Brennan thinks he's going to be able to do is kind of craft this standard that will allow the police to stop people on less than probable cause, that he thinks will kind of placate this election year sensibility and not go too far. But I think they just didn't realize exactly what they were unleashing because, so this one, interestingly enough, even Thurgood Marshall joins. He joins the majority in Terry versus Ohio, which is interesting because in a lot of the other cases I talk about in the book, he's either the lone dissenter or a chief dissenter. He sort of sees what the others don't. And here he goes along with it. He had just joined the court though. And so I think part of it was he was new because just a couple years later, he's like, oh God, I think about it like from Arrested Development, where he's like, I've made a big mistake.
Yeah.
And so
Yeah.
later he realizes, oh gosh, I should have never gone along with it, because it turns out, the only person who dissents is Douglas, and he writes a whopper of a dissent in this case, which is basically like, you will come to regret this. This is how you create tyranny. You cannot allow law enforcement to do this to people. But I think the Supreme Court was just so caught up in not another policing case where it looks like they're going against society that they come up with this new test that's a lesser standard. And then what to me is so interesting is after the case is
And what's the test, by the way?
Oh, so the test, they actually aren't super clear in Terry itself, but it comes to be a reasonable suspicion test, which, as you were saying, is like tries to capture that officer sensibility that because of their experience and the things that they've witnessed, they have a reasonable suspicion, is ultimately what the test becomes. In practice, it's it's a pretty low bar. You're
The affidavit always starts with, I've been an officer for such and such years, and invites the court. It's sort of a similar dynamic as we were just talking about, Rachel, which, invites the court to say, what do I know? But this guy, et cetera.
Right. And it's, things like furtive movements,
Right.
a Black person in a white neighborhood that, it doesn't quite look like they belong. I mean, we have cases that all say, yeah, those
Oh,
are
yeah.
the kinds of
No.
things.
There's a lot of review articles where, with one, it is reasonable. With the, you can take the same factor and
It's
reasonable suspicion is pretty darn loosey-goosey, right?
Yeah. So, stopping people at the airport if they get to the airport too early, if they get to the airport too late, if they have a lot of luggage, if they have no luggage, all of it
Right.
has been sufficient for reasonable suspicion to stop people. So it ends up being kind of anything. And what police do after the case is, they realize, hey, this could be a really great tool for us. And so you have places like New York City embarking on stop and frisk practice that at its height was stopping 700,000 people a year. And that really creates some negative interactions between the police and communities, because,
It's a policy. I've been involved, but the Giuliani Federal Tuesday, whatever, literally the centerpiece of it, and I've done things like this myself, is the command goes out, really make promiscuous use of stop and frisk for this reason.
Talking Feds is supported by the Brennan Center for Justice. In this new political era, the Brennan Center will do what they do best: defend the Constitution and the rule of law. They're prepared to fight against presidential overreach and will continue advocating for reforms to resist weaponized government, stop billionaires from corrupting our elections, and ensure every eligible American has the freedom to vote. Stay informed by visiting BrennanCenter.org.
I just want to say a couple of things by way of a, sort of valedictory comment. So you've got 6 in the book, and you look at the book. We also have plea bargaining. Man, that's big. Disproportionate sentences, overcrowded prisons, and racial bias. And you look at them all together, and they have this kind of what seems an overwhelming effect. Of course, the court decides cases one at a time. You've given originalist arguments, and you've given the sort of originalist tendencies, including where they lead to quote unquote unpopular results of certain members of the court. So that those together, especially when you see the whole kind of menu, add up to what seems like, maybe they would consider it. And the counter argument would be something like, Professor Barkow, you're dreaming. Really, do you really see any appreciable possibility that any of these gets reconsidered? How does it happen? So let's just sort of wind up with your sense of, for everything you've laid out and all the problems, these are now structural parts of the criminal justice system that ain't going anywhere.
Yeah. And hey, it's fair. I think I wouldn't bet money on myself for this. So, but here's why I think it's valuable to do this anyways, because, so, you mentioned before that flag burning case that Justice Scalia decided, and he loved
US
mentioning that.
Wisconsin,
He mentioned that whenever he would give speeches, because he would tell people that wanted to say he was a results oriented judge, he had to vote that way. And of course, he doesn't like to see the flag burned. And Mrs. Scalia, when he came home after that decision, said the flag, it was a big part of his speaking. And it was helpful to him, actually, because I think it's good for a justice to be able to say, look, I'm not voting my preferences, I'm voting my methodology. And it's good to have a counterexample. And you know what I think is really interesting is that a lot of the current justices don't have that. And these cases could be valuable to them because they are the kinds of cases where it's not a traditional conservative valence. I tend to not think of these cases as liberal or conservative myself. I sort of just think of them as liberty protecting. But these days it would probably be more associated with a liberal perspective because it would be, ruling against law enforcement interests. So if a justice were to say, actually, you cannot detain people just because you claim they're dangerous after they're arrested, that could be their flag burning case. They could say, hey, look, yeah, I overruled Roe in Dobbs, but I also overruled Salerno, because what I do is I go where the Constitution takes me. So I think there's a way in which it's possible that the justices could see this as the opportunity that it is, that, to show the world they are principled and they are taking methodologies where they lead them. Now, do I think all the justices would do that? No. Do I think
only
that
takes 5?
Do I think there's any chance in the world Justice Alito is going to do that? No. Justice Gorsuch, though, yeah, I actually do. I think he has done it, and I think very possibly would do it again. If he was convinced by the history. And as I see, these cases are great because the history is such a slam. The only one that so I have 6 cases in the book. There's one case, which is McCluskey versus Kemp, on what you need to show for racial discrimination, that I point out the history there is a little less clear than it is in the other context. But the other 5, these are like slam dunk cases. And so I think there are some justices that would go along with it. And, honestly, even if that doesn't happen, then that's my kind of second thing, which is I think there's some value then in proving then that they are hypocrites, because if it turns out that no, they won't do it because it produces a liberal outcome, then you know what? Let's call the justices out on that. Let's say, hey, look, these are cases that are wrongly decided. They fail your stare decisis test that you talked about in Dobbs, that I'm sure we're going to see in the case involving independent agencies. And if you're not willing to overrule these, then it's just going to prove that, in fact, you just have a conservative agenda. And so that's valuable, too, because I think it's valuable for people who criticize the court on that basis to be able to point to cases like this, because you can't just say, well, you didn't decide the case the way I like. I do think you should take what they're claiming is their methodology seriously and point to a case that should have come out differently. And, these are those cases. So I'm hoping it, obviously my hope would be that they do overrule them or they limit them dramatically because I think they're wrongly decided. But, if it turns out they don't, and this is too embedded and they say not, then I think they are definitely cases that can be used to criticize this court as engaging in hypocrisy, because it'd be no more difficult to overrule these cases and integrate that into the administration of criminal justice than it's going to be to get rid of all independent agencies and, and make all of the people who are in charge of them removable at will by the president.
Well, look, just a few points. I mean, we do know that the law enforcement goes with the flow. And as Miranda now has become, an absolute embedded structural point there, they carry around the cards. They even say that they like it. I'd point to one more thing, Rachel, besides promoting the overruling and potentially point of criticism in court. But these are, canonical cases and principles that when people think about them a little, they understand, well, there's at least some tension with our charter document. And I think that's very valuable in and of itself. Anyway, one thing is certain. If they do pull the trigger on any of these, this will be definitely cited prominently in the notes. You've sounded a call that may increase in volume. And in any event, congratulations on this achievement by Harvard University Press. Where can people get it if they want to read more?
Oh, you can get it wherever you like to buy your books. If it's Amazon, if it's your local bookseller, independent book.
Supreme Court bookstore, you think will have it down? Maybe not.
I don't know. That's a really good question. I would love that.
Yeah. They have
and
the
it's
rank
your
list
library, by the way. It's fine with me if you just check it out of your library.
Very good. Hey, a pleasure talking to you. Hope to see you again on the kinds of issues that concern you and you've done such great work in. And talk to you later.
Oh, it was a pleasure, Harry. Thank you so much.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.